My dear Jafar Ali Saf and his notary friends, it is really happy to know that a notary association is formed, and we have formed this association to fight against the Notary's Amendment Bill 2021. In this regard, I want to register my view about this Notary Amendment Bill 2021. The Notary's Amendment Bill 2021 contains 3 sections, and there were 3 points. Section 2 says that the notaries appointed for a term of 5 years are entitled to renew their certificate of practice for a 2 terms of 15 years, 2 terms of 5 years, which means that the lifetime of a notary, the practice time of a notary is restricted by 15 years. The section 3 speaks about digitalization of notary work. Then section 4 of the amendment bill speaks about power to suspend the certificate of practice in the event of a complaint being received as against any notary for the misconduct. The main object of this bill is to restrict the lifetime of practice of a notary by 15 years. Why should the government limit the lifetime of the notary practice by 15 years? What is the reason? They may say that they wanted to give some opportunities to young generation, young lawyers to come and practice as notary. I don't think that would be the reason. My question is, can they adopt the same practice to any other professionals? Can they pass any act or law saying that a judge should be a judge only for 15 years? Can they say that a police officer should be a police officer only for 15 years? Can they say that the person who is admitted to the government service or government servants should practice as a government servant only for 15 years? Or can they say an MLA or MP who is elected as an MLA can contest for the election only for another 2 terms? No, there is no such law, there is no such restriction, there is no such lifetime fixed for any other professionals or any other persons who is doing their professions. In that case, why should you wanted to fix the lifetime to notaries alone? The idea is the present government wanted to create vacancies. By passing such an act, automatically the person who have already completed 15 years of practice will not be eligible to renew their service, notary. Automatically there will be a vacancy. So the present political people wanted to create vacancy, and they wanted to appoint their own group of people or the people through whom they want. That is the one and only idea behind this amendment bill, to my knowledge. But the thing is, it amounts to a violation of the Constitution. It amounts to infringement of fundamental rights. Number one, when a government or when a law cannot restrict the lifetime of a police or judge or politician, government servants by 15 years, how can they restrict the notary's life by 15 years. So this amounts to discrimination. When there is no lifetime of practice is fixed for any other class of professionals, they cannot fix and restrict the lifetime practice to the notary. If they do so, then it will amount to violation of Constitution. Article 14 attracts, it amounts to discrimination, discriminating the notary alone with the rest of the profession. So it amounts to violation of Constitution. Number 2, when we join advocate profession, we work there for about 10 years of practice, then we are entitled to apply for notary. After 10 years of advocate practice, then alone we are eligible to apply for a notary, and we get an appointment as notary, then we practice as a notary. As far as the advocate profession is concerned, nobody knows which field he is going to practice in future. It is like a wood on the river. Our profession, our advocate profession travels like a wood on the river. So someone gets some cases in one particular civil court and criminal court, or in particular place, Tirunelveli, Tuticorin or Sirivegundam. So the persons who gets a case in particular area or particular court specializes his profession and restricts the area, and he sits in a particular place and says, I will be a advocate in Tirunelveli court, family court. I will be a advocate in criminal side for criminal matter, Tirunelveli. So like that, every advocate, when doing the profession, automatically fixes his type of work, his type of job, his type of profession, and he specializes in one particular field and sits there and continues to practice in specific area where he gets brief or work or cases. Automatically everyone specializes at one particular point of time. Like that, the notaries also, once they get an appointment as a notary, they restrict their profession and they loses many of the other opportunities which is available to other advocates. The notaries are constrained to be there in his office for the entire period. Once the office opens by 9 o'clock, the people expect the notary to be there by 9 o'clock, and he should be there till 7 o'clock, 9 o'clock, 10 o'clock, whatever the time he fixes, he should be available. Otherwise, if the client comes and the notary is not available, he will goes out. The notary is not there. So automatically, the notary profession compels a notary to be there. So he loses his advocate practice. He cannot take cases. He cannot go to the court. He cannot go take any other briefs like another advocate. Automatically, notaries fixes in one particular space, one fixes in his office, and waits there throughout for the entire day and spends his time. So every notary specializes his nature of profession job, and automatically the notaries are not able to do any other work, or loses all the other briefs, all the other opportunities. So if the act is passed, just imagine the situation of a notary. For 10 years he will be an advocate. For another 15 years he will be a notary. After the 15th year, he will be a useless person. He will be thrown away from the advocate profession. So during the 15 years, he may not have any advocate profession, he may not have any cases, he may not go to the court, because he has to be there. Once he specializes in particular notary work, automatically we will lose all the opportunities. We cannot go to the court. Court work we cannot do. We do not have time. So after the 15th year, we will be losing our opportunity. Then we will be constrained to throw away from our entire profession. This is like a person is compelled to start his business from the beginning. If you do not become a notary, automatically you would have been practiced in this advocate profession for about 15 years. We would have gained clients field and we have specialized in any particular field, and we will be in a comfortable position to run the rest of our life. If this act came into force, automatically we will not only lose our notary profession, but we will be constrained to start a new profession as a beginner. If you practice as an advocate for about 10 plus 15 years, 25 years of practice, then they will be in a comfortable position to run the rest of our life in a peaceful manner. Now this act aims us to go to the junior level, day one level, advocate day one level. You have to go to day one level, then we will have to again start an advocate profession, and then we have to work hard like a junior, and we will have to practice, which is very, very, very dangerous situation to the people who are in this notary field. If you go through the amendment bill, there is a lakana. Supposing a company wanted to send some of their employees to their home under retrenchment, or supposing the government wanted to reduce their employees and wanted to send them and terminate the services through voluntary retirement. As per the law and as per the practice prevalent in India, the company and the government pronounces a scheme, voluntary retirement scheme and voluntary retirement scheme or any other scheme, through which the government and the company offers some sort of benefit, settlement benefits to the employees who are returning from the service. If you go through this act, this amendment bill, is there any settlement scheme to the notaries? The notaries are not retiring from the service. The government, by way of passing this amendment bill, imposes or sends the notaries from the service. So this is a self-determination done by a government. So if so, is it not necessary on the part of the government to declare a scheme, a settlement benefits, voluntary benefits? There is no settlement, there is no pension, and there is no gratuity, or there is no any other benefits declared in this amendment bill to the notaries who are going to be terminated through this amendment. This only shows that the government and the lawmakers did not apply their mind. They did not apply their mind in drafting this amendment. They did not think about the future of the notaries. 10 years they practiced as advocate, and another 15 years or 20 years they lived and served as a notary. What are they going to do? How they are going to live to the rest of their life? What type of income they have? What type of are they going to get any pension or any retirement benefit? Then how can they lead the rest of their life? It was not considered. It was not properly applied by the lawmakers who has drafted this bill. So it is nothing but a violation of Constitution, arbitrary exercise of the power, arbitrarily this bill was drafted. Just 5 sections, and nothing is considered about the future of the notaries who have been practicing years and years and dedicated their service to the society. Strictly speaking, the Notarial Act is a part and parcel of the government. The government has to do the notarizing act, notarization, all the jobs and services rendered by the notaries are part and parcel of the services attached to the government. So the notaries are doing the government services for which government did not pay any fees, government did not give any salary, and their earnings, salary, income are collected from the clients who offered any such notarial services or attestation or other work. So what is the award, what is the retirement plan, what is the termination scheme pronounced to these notaries? So we people, notaries, practiced as an advocate 10 years, then promoted our service to notary, and we are practicing as notary for the another 15 to 20 years. Now we have a lifetime of another 15 to 20 years, depending upon the age, and we have our life. We wanted to earn something. We have to get some income. We can do only those profession which has been developed by us for years and years. My senior used to say an advice to the juniors. When we joined our senior, Mr. M.R.M. Abdul Karim, he said that advocate profession is like a coconut tree, which means that you have to work for 10 years, you will not get any benefits. You will have to work another 10 years for which you will get proper income. After 10 years, after the completion of 20 years, you need not work hard to the level you have worked for the first 20 years. You can comfortably sit in office and give consultation, and we can earn the required amount through consultation or the minimum services which we can give to the society. Now, we have developed our notary services. All of a sudden, the government, through this proposal, wanted to put an end to our notary services, and our situation is worse than that of the Ukraine refugees students. Now, during the Ukraine war, the students who have gone there for studies are returning India, and what they are going to do for their further studies. The person who came here after 1 or 2 years of study, can they continue the studies is a question, big question. Now all the people are thinking about their life. Our position, notary position, is worse than that of that Ukrainian refugees, student refugees. For 15 years we have practiced as notary. Now, through this proposed amendment, they are putting an end to our earnings. They are putting an end to our profession. Then what will be the future of us? It's a great question mark, which is not considered by the drafting committee. It clearly shows that it's a non-application of mind. They have not applied mind. They have arbitrarily passed the order to create some vacancy in the notary field, and they wanted to make fresh appointment to the people to whom they want. So this is nearly an arbitrary exercise of power. It amounts to discrimination. It is against the principles of natural justice. This is my view. Supposing if we ask a judge, after 10, 15 years he has to resign his job and to go and practice as an advocate. Is it possible? Can they face this pain? If you ask a police or government servant, after 15 years of his service, he should resign and go and apply for another post and have to join as an apprentice and join the practice. Can they do? They cannot do. When all the other communities cannot do, how can the government can expect a notary to quit his entire profession, to go and join and to go and start a new profession after the 15 years of his service? It is totally unfair. So not only it amounts to discrimination, violation of the fundamental right, constitution, it also affects the freedom of profession. It also amounts to liberty. I can choose my profession. So I studied my BL, then I became an advocate, and I practiced an advocate for 10 years. Then I applied for notary. Then after getting appointment as a notary, I am running my office as a notary office and doing the service as notary. So this is my freedom of choice. Now the government or the law cannot push me out of this profession, and they cannot ask me to go and start a new profession. It is unfair. So freedom of profession is violated. Liberty is also violated. Private rights. It amounts to infringement of private rights. My right is infringed. So in all the ways, the act, this amendment proposal proposed by our present government is totally violative of constitution. It's a violation of the fundamental rights. So we should all give our support, and we should all fight it for tooth and nail to see that this act is not passed. And even if this act is passed, we should challenge this act as it amounts to a violation of fundamental rights, infringement of our constitutional fundamental rights. And so we really thank Mr. Jafar Ali and the other office bearers who has created this association, and I give my support to this notary association to fight for our justice. Goodbye.